Shalom Aleichem and welcome to Online Smicha. We all know the opening words to Parshas Mishpatim, where the Torah says, "Ve'ela mishpatim ashetasim lifneim." These are the laws that you place in front of them. Who is lifneim? Them. Those are the Jewish judges, and they teach Klal Yisrael, and they settle disputes amongst people. There is a section in Shulchan Aruch in Choshen Mishpat, Simin Chav Vav, that tells us the halacha that we learn out from this pasuk, that lifneihem, that all disputes and all cases have to be settled in front of lifneihem, in front of a Jewish court, a Jewish bezdin. If Nebach, Rachman Latzan, there are two Yidden who are in a dispute, the way to settle it is only lifneihem, v'loy lifnei akum, and not akoi shel akum, and it's prohibited to go to a secular court to settle this dispute, and only in certain circumstances, very difficult circumstances, that the halacha would allow for a Jewish case to be settled in secular court. Just to show you how harsh this halacha is, the Mechaber in Siman Chav Vav, in Choshen Mishpat Siman Chav Vav, the Mechaber writes, "V'chol haba lidoim b'fneihem." Anybody who takes his case to a Goyish court, Harezeh Russia. God forbid, he is who we call a Russia. Uki'ilu chiref v'gidef v'herim yad b'toiras Moshe Rabbeinu olav Shalom. It's as if he cursed and he lifted a hand against our Torah, the Yiddish Torah that was given to Moshe. That's how harsh the statement is about somebody taking his dispute to court. And the Ramah goes on to say, V'yesh biyad bezdin litchoisoi ulahachrimoy. Bezdin, if this person, individual that's taking his friend to court, it's not a friend, taking his opponent to court, if he would listen to Bezdin, Bezdin has the rights to put him in a cherem, to take the case out of court. All right, so you're not supposed to do that. Now, there is always the person that, either didn't know or he feels that he's going to gain. Maybe the Dayanim wouldn't hear him enough, wouldn't see the damage, etc. And he feels that he will get better in court. So there's this question that's discussed. What happens to a case where Reuven took Shimon to secular court, thinking that if he presents his case and he presents his evidence, the verdict, he has such strong proof, such strong evidence that he's sure that his friend will be found guilty and he'll have to pay him the sum of $10,000. So the case went on in court, and he didn't listen, and he brought it to Goyish court, and the verdict was that that person was guilty, but somehow the number that the court ruled that person is obligated to pay is 4,000. 10,000. 4 out of the 10, 5,000. But he didn't get exactly what he felt he was deserving. So as he's walking out of the court, his friend tells him, Chaval, you should have listened to the Torah. If you would have taken the same case to the Bezdin, there was a good chance the Bezdin would have ruled that you have to pay the full 10. And a flashing bulb goes off on his mind. He says, maybe it's not too late. Perhaps I could still take him to Bezdin, and hopefully now Bezdin will. This guy, we're both from a Yidden, even though the secular court only ruled that he has to pay $4,000 or $5,000. But I'm sure if I could get a Bezdin order saying that he has to pay me 10, he'll give him the 10. Will Bezdin accept this type of case to listen to once it was already discussed and a verdict came out in a secular court? Now, this is a discussion that starts in the Beis Yosef, and the Ramah in the Shulchan Aruch, the Mechaber doesn't bring this, but the Ramah in the Shulchan Aruch brings two opinions. The Ramah says like this: Mi shahalach ba'arkoi shel akum, one who went to a Goyish court, v'nischayev b'dineyem, and he was obligated. They found him guilty, or found one party guilty, to pay. V'achakach chayzer V'tavay lifnei dayana Yisrael. And then he wants to, the defendant, not the defendant, the plaintiff wants to take the defendant a second time to try to get more out of him by bringing the case, the same matter, to Bezdin. Yei, one opinion says, she'enis kakim loy. He lost his chance. He settled this court. He settled this matter in a goyish court. Whatever they paskin, it's it. We will not listen to this case. V'yei shomrim, and there are those that say dinis kakim loy. I mean, a lot of people do nebach averis. They don't listen. Doesn't mean that we don't treat him like a regular yid. Every yid has a right to come to Bezdin, and Bezdin should settle the dispute. The fact that he went already to court doesn't necessarily make him lose those rights. There's a machlokes. Comes the mechaber, the Ramah, and the Ramah paskins v'hashvara rishona nirli ikar. I believe the first opinion is correct, that once somebody goes to court, not only if the court paskins that he only deserves to get $4,000 or $5,000, that's the ruling. He lost his chance to go to a Bezdin to try to get more. Why? So there is from the Tumim, there are from other Svarim that say there's one or two basic reasons. One, the obvious reason you're going to think is, listen, if you're talking about a man who doesn't listen, we gave you the chance. The chance was to come here at the first and listen to what Torah says. If you don't do what Torah says, we don't want to listen to you. We don't want to hear your case. But there is, it's deeper than this, because it's not fear just to say because he made a mistake, he's doing tshuva now. The answer is because halachically there is a ruling of dina de malchusa dina. Dina de malchusa dina means that whatever rule the government establishes, Torah says we have to follow that rule. Uvechein, what really comes out like this: as long as the case is in front of us, in front of Bezdin, if the Bezdin has its ways how to paskin the din, the ways of the paskin the din is the Shulchan Aruch, and even in Shulchan Aruch, a lot of the decision making of the dayanim will depend sometimes on the way the world works and what's considered a transaction in the world, and what's considered what legal laws are available in these matters. But once Bezdin makes a decision, it's a decision. When you took that rights away from the dayanim because you let somebody else make that decision, Torah says we have to listen to that decision. Even similar to this, we find earlier. We find similar cases that there are certain people that are disqualified to be originally to be part of the judges or part of the Aidin, the witnesses. Sometimes if the parties are willing to accept, they know that these people are not the most suitable people, but if they say that we are willing to accept these second-class people, sometimes the halacha is that we have to listen to that too. The same would be over here. But even more, not only we look at the court ruling as a second class, but we say that Torah says that you have to listen to them because of Dina de Malchus or Dina.